rate of the membership could mean that your members are leaving the scheme because, well, they're leaving this earth. It could be that your membership is dying off. Is that part of the reason for the decline? Well, Chair, I think what the graph really highlights is that we must remember that it's fair to say that as people get older, their healthcare needs also change, and they definitely hold on, to healthcare cover, to the extent that they possibly can. And it also suggests that as people get older, if they can certainly get into medical schemes, to access good quality health care, they would do that, and it has an impact on the risk profile of medical schemes. And, to the extent that the risk profile deteriorates, it also has cost implications. But that's not my question. My question is whether the decline in membership has got to do with deaths of members. Okay, Debu, answer that.
Thank you, Chair. Just to maybe just assist Mr. Musomatang, I think the broader context of this is if you have the environment that schemes operate in now, firstly, you have an open enrollment, so guaranteed participation, should you choose to. So participation is firstly voluntary. So the state does not say if you're in the formal sector, you must take up medical aid, for example. So that's the first point. Then your contributions are then not rated based on your clinical profile. So the scheme does not have the ability to say, like you would, for example, in short-term insurance, to say, if you're a 24-year-old with a fast BMW, we're going to charge up your premiums because you represent a higher risk than a 55-year-old in the same car, right? So that's a second constraint. And then in that environment, you now have a statutory guaranteed risk benefit in the PMBs, which you have to cover at cost. So all of that, creates a pressure on the schemes to manage funds. That's the first. In terms of the decline in the profile, it's not really that. I mean, if you just look at CMS data, I think people, and the one graph I think before this actually shows that your proportion in your over 40s, your proportion of the scheme population relative to the South African population is sometimes as high as 35%. We often talk about medical schemes represent 16% of the population, but it varies by age. Mm-hmm. And there's a stickiness over time. As people get older and sicker, they tend to stay on the medical scheme over time. The bigger issue, so it's not to say people don't come off. As the economy declines, as employers change their subsidy policies, as they retrench, sure, people do come off the bus. And unfortunately, they become the burden of the state in that case. But I think the bigger issue, the point that we're trying to make is the voluntary participation also creates an option for younger people who are healthier, who would create a risk cross-subsidy and an income cross-subsidy should they participate, are staying off. And what you'll see, there's a graph which, we could share with the panel if you haven't seen. It was by Inside Actuaries, I think back in 2013, that actually shows the South African population and the medical scheme population by age. And what you see there is the medical scheme population is shifted to the right, which means slightly older. The actuaries will tell you that every 1 year shift in a population in a risk pool adds about 2% of cost additional. So every 1 year shift. So if you have two risk pools, or if you have a single risk pool and nobody new joins and nobody leaves, that population a year later, they're all 1 year older. Just by virtue of that 1 year shift, you'd need to budget an additional 2% just to be able to cover their healthcare needs. So, it shows the shift to the right, and then it also shows that younger lives actually stay on their parents, so they participate. They stay on their parents' medical aid. When they become independent, there's a dip in the population, so they come off. And they only start participating again at a point of childbearing age, so when they start having families. And they actually quantified that gap to say if we were to say everybody must participate who's employed, you'd probably generate another 15 to 17 billion per annum into the risk pools. So I think the challenge is as funny as it sounds, when the graph you're asking about, Chair, actually simplistically means the employed population in South Africa is actually growing in numbers faster than the medical aid population. And we all know how high the unemployment rate is. That's how critical this issue is.
Yes, no, I understand. But if one looks at the category you're dealing with, if you've got 20 employed people, the graph shows that in the next 5 years, only 15 of those would remain members of the schemes. The question I'm trying to understand is what will happen to that 5? Of course, if people die, they're no longer employed. But those who remain in employment are also leaving the schemes. That's what I'm trying to understand.
No, Chair, I think what it's saying is that the 5 don't necessarily die. They just come off cover. So they basically become the burden of the state because they have to access care somewhere. The 15 then remain, and depending on the mix, so if it's 15 older people, then the risk profile shifts, it basically worsens. So that risk pool would have to provide additional funds to fund the 15. Whereas, if the 5 who leave are younger individuals, then what you do is lose contribution income. But if the 5 that leave were older, then it might actually be a positive impact. It just depends on the mix of lives that change.
But isn't there another explanation that the contributions are too expensive and unaffordable?
So, Chair, we agree with the fact that the sustainability of contributions over time is a real challenge, and I think schemes have gone on record with the HMI process. And some of the submissions there, just, if I try and recall, would show that some of the bigger entities are reporting CPI plus 5, CPI plus 6 sort of contribution income on an annual basis. We can check the numbers there in the HMI submissions. And I think 5% above CPI is not, it's significant. What those numbers also show that the greatest proportion of that is not pricing. It's not tariffs. Tariffs tend to contribute about 0.5% to 1% of the above CPI increase. It's the demographic deterioration adds cost, so the 1 year and 2 year shifts that require additional funds. And the second part of it is the supply side dynamics, which deal with where schemes actually have to purchase healthcare. So the lack of regulation within the health facilities market, for example, an environment that is predominantly fee-for-service based in terms of remuneration, etc. There are other factors. Influx of new technology, for example. If you have new devices that are more expensive into the market, they do cost more. And obviously another supply side factor which we cite is fraud, wasteful care, and billing abuse. So that that is a supply side contributing factor.
Now, on that issue of the factors that are contributing to the high contributions, what do we know about fraud, waste, and abuse?
I think we were actually coming to that.
Yeah.
Now, Chair, we'll get to that point just now. In the next slide, if I can wrap up the point that we want to get across with reference to this one and the figures that have been accessed from the Council for Medical Scheme, report. The point that we want to highlight here is that there's a lot of pressure, including financial pressure, that medical schemes find themselves under. And so managing these costs becomes quite critical. And to the extent that fraud, waste, and abuse makes an unwelcome kind of contribution to those kind of pressure, it becomes critical for all stakeholders to do their best to manage that kind of issue, in addition to other challenges, that we are facing. So I'm going to move off the slide. Now, the CMS as a regulator have certainly recognized, Chair, the challenge that fraud, waste, and abuse is for medical schemes, and took the initiative to bring together market participants to address this challenge earlier this year, as I've indicated. Now, this also followed a national initiative to address fraud and corruption in various sectors, of the economy. And here we're also making reference to the National Anti-Corruption Forum, which involved the presidency.
Mr. Masamatane, can you just, I see what your slide is dealing with, but
Yes.
What I don't see on there is the BHF, for example, has told us that approximately 28 billion rand is lost to fraud, waste, and abuse annually. Is that, do you have a figure like that as well?
Now, as far as that figure is concerned, we from an HFA perspective, given our participation in the Fraud, Waste, and Abuse Summit that is led by the Council for Medical Scheme, we chose not to duplicate that estimate. So we are deferring to the numbers that have been estimated by the Council for Medical Scheme. Now, we observed that earlier in the week, the BHF was talking about 28, and there was a lower amount that was referred to from a CMS perspective. So my best response to that is that we defer to the calculations that have been done by the Council for Medical Scheme in that regard. But what I do want to highlight, Chair, is that there was a specific question in as far as the component of fraud in particular. And for lack of a better word, there was some confusion in as far as what that amounts to, trying to isolate fraud. And we may have walked away from the discussions on the day thinking that having given an estimate of 15% of total claims as what our exposure may be, in relation to fraud, waste, and abuse. We came out of the discussions with a suggestion that, about 3 to 6% of that 15% may be attributable, to fraud in particular. We had informal discussions with BHF after, the conversation, because based on the information available to us, just from engaging other players in the industry, the 3 to 6% is actually relating to total claims, as opposed to the 15%. So by that I'm saying 3 to 6% of total claims is the right estimate in as far as fraud is concerned. But it's fair for us to say it may be wise for the panel to just check that again with BHF, because we did have an informal conversation with them about, so that they can just confirm instead of me saying something making reference to them.
But didn't the 3 to 6% come from an American survey of medical aid and fraud in the medical aid market in the US, not South Africa?
That is correct, Chair, and it happens to coincide with other sources that we have internally from big administrators who do similar kind of estimates. And it was against this background that we were raising the question with BHF and saying, look, you said 3 to 6% of the 15%, and in that informal conversation they did indicate, yeah, look, the right estimate is between 3 to 6% of the total claims. So it happens to be more or less in the same range as what we are experiencing here.
Chair, if I may.
Yes, Mr. Pala.
Thank you, Chair. I think we would probably need to just double check with the BHF. What we know is the figure cited by the Registrar of Medical Schemes of 10 to 15%. My understanding is this was based on global research in advanced healthcare markets where you have health insurance, etc., where you have stronger data. And I think the point was we've got no reason to believe that our situation would be any different. I think that's the kind of starting position to say globally what's reported is 10 to 15%. And if it's 10 to 15% in our market, then therefore it's up to 15% of, I guess, 144 billion rand, which would come out at about 22 billion just of this number.
But you haven't got data and research in relation to the percentage of claims, to how much is lost through fraud as a percentage of claims amongst your members?
Not that we know of, Chair. I think what we know is this estimate, which has been quoted by the CMS. But again,
but that is a global study, which you're trying to superimpose here. I'm saying, are you doing your own investigation as to how much is lost to fraud? I mean, it can't be that complicated amongst your members.
It's not as easy as simply just, it's hard to detect how much fraud is. I mean, if you look at some of the figures that have been reported on recoveries, I think two administrators were quoted by a group a day or two ago. And if you look at the total contribution income for the schemes they manage, you'd probably be coming out at about 1%, maybe 2% of total contributions recovered. That's a different figure from saying what is the exposure. So you may, if I have 10 rand and I'm being robbed of 5 rand out of the 10 rand, but I'm managing to recover the 1 rand of every 10 rand. So it's the two figures. I'm just simply saying that first figure we don't have hard data on, but just based on global evidence, I think the CMS's narrative on this was that there's no reason to believe that our situation would be much different.
So the problem, Mr. Paleng, is to just put it to you so that you can have an opportunity to respond. It's not so much that we're trying to extract numbers from you. So the big story is this. Schemes are saying in their submissions, we are losing 28 billion rands per annum. We are justified in invoking drastic measures of recovery. Sometimes we recover 1 billion if we're lucky, sometimes 1.something billion, sometimes 500 million. The doctors on the other hand are saying that these investigation techniques that you are using are unfair, disproportionate, and unjustified. So BHF says to us, we think fraud accounts for 3 to 6%. Initially, I thought it was 3 to 6% of the 15%. Now you are saying to us it's 3 to 6% of the total claims. If we know for sure what is the amount attributable to fraud, we can make an informed assessment as to the justifiability of these investigation techniques and the recovery that is used. But if we also know that a lot of it is attributable to waste and abuse, which is not necessarily the fault of the doctors, but it is a systemic problem within medical schemes themselves, that gives us a completely different picture to the justifiability of the drastic measures that are used to implement Section 59. So that's what we're trying to debate with you, and we're not trying to catch you out.
Thank you, Chair. And yeah, absolutely. I think we're on the same page. We're just trying to just share our insights and hopefully, bring the panel to an understanding. I think the analysis is not different, is not inconsistent with what you're seeing on the recovery. So I think what's being said is 15% is fraud, waste, and abuse. Now, 3 to 6% is the fraud element. So the WA would then be 15 minus 6%. So that's essentially what is being said. I think on, I'm not a lawyer, but I think the difference mainly, even if you read the definitions in the CMS fraud charter, fraud, waste, and abuse charter, is mainly around intent. So, did you intentionally kind of misrepresent a claim and commit fraud, or did you bill codes that you shouldn't have, or are you practicing in a manner that is inconsistent with good clinical practice and billing accordingly? I think the point there, Chair, is the onus, I think, is on the health practitioners to also bring themselves up to speed in terms of how to clinically code and bill appropriately. Sure, the industry has to play a bigger role in that, so that we have a common standard and a common understanding, right? Fraud is fraud, so I'm not even going to go there. But I think from a medical scheme point of view, whether you've paid out a fraudulent claim or whether you've paid out an incorrect amount because a practitioner billed erroneously or inappropriately, it's still money that is paid out by the scheme that should not have been paid out. And I think it's in that sense, our understanding is it's in that sense that schemes are saying this is inappropriately paid by the scheme, and therefore it needs to be recovered for the benefit of the member. So if you pay for a consultation and you're expecting it's 400 Rand, but there's padding in terms of what's on the claim itself, fraudulent, intentionally or not. If a claim is 600 Rand and it was meant to be 400 Rand, the schemes, our understanding is the schemes feel that 200 Rand was wrongfully paid out, and it needs to be recovered to the benefit of the scheme and its members. So that's kind of our understanding.
But what we heard is that what the schemes do, or the administrators, is not to claim back the 200 Rand. There isn't an exact quantification of what is due to the medical scheme, what is appropriately and lawfully due to the medical scheme, because there was a finding that it shouldn't have been paid over to the practitioner. There isn't a quantification of that amount. There's an aggregation over a period of time.
Thanks. Thanks, Chair. I thought...
let's go back to Mr. Musumutani then. Are you saying you've
No, I was
discharged your
trying
mandate?
I was trying to answer the question that I think from an HFA perspective, HFA is not that close to the scheme operations, and these procedural aspects would differ from scheme to scheme and administrator to administrator. I think you'd probably glean more information from, the schemes and administrators on how they actually, whether or not that 200 Rand would be recovered and how it's done. I think the HFA is not close enough to that level of operational detail.
No, but I mean, you can give us your own perspective about whether averaging is right or not.
In what way? I think, Chair, you need to find a mechanism that is fair and reasonable. And I think that's the insight we're hoping, some of the clarification that we hope this process will bring to the environment. CMS had been working on a code of good practice. We know this. We are part of the working group and the coordinating committee. And these are some of the issues that actually came out from the summit, to say we must have some form of standardized approaches to these issues. So we welcome that, and we hope at the end of this process we will have better clarity.
Thank you. Let's finish your slides, Mr. Musumutami. We've distracted you from your...
No problem, Chair. I think just to move off this one, we have, to a significant extent, touched on all the relevant aspects, one way or another, and went as far as touching on the challenges that are faced by medical schemes with reference to this up to 15% of total claims. One of the things that becomes quite relevant in this regard, Chair, are the findings that have been raised by the Health Market Inquiry, albeit they, provisional, which suggests that, the HPCSA, there are inadequacies in as far as penalties that are imposed in as far as these acting as a deterrent to unethical conduct. Now, I appreciate that there was a conversation that took place in as far as, this is concerned with the HPCSA. But we find it quite relevant, in as far as what the health market inquiry has raised, including the fact that there is a backlog of complaints and inadequate sanctions that are imposed by the HPCSA. Now, having said all that, our understanding from interacting with the schemes and administrators is that these inadequacies, are not necessarily resulting in medical schemes and administrators doing what they believe is beyond the boundaries of, laws and regulations. They are really applying the recourse that is available to medical schemes and administrators to recover, what has been lost, to the scheme as a result of fraud, waste, and abuse.
Mr. Musamotane, just to pause on that point, I'm struggling with that submission because on the one hand, you are saying you are not close enough to the schemes to know the detail of the information, but on the other hand, you're saying they comply with the regulation. So, yeah, I'm struggling with how to make sense of that because I'm resisting going into the detail with you because you say you don't know, but at the same time, you are making submissions suggesting you do know.
Okay. I think that's a very fair comment. It's very possible, for us, being an association that is made up of medical schemes and administrators, to find ourselves expressing views and assurances that, are given in the course of the interactions with our member organizations. And I guess at the same time, there is carefulness on our part not to present ourselves as knowing all the details at operational level that the medical schemes and administrators, certainly do. We do have a benefit in this process, I would think, of, administrators and medical schemes being expected to come to these, sessions and make presentations which will provide the panel with an opportunity to interrogate the nitty-gritties of how they're carrying this out. So I fully understand the concern that you have in as far as at times expressing details that one would be able to do if we were close to the operations, and at the same time saying, look, we are not close enough.
Can I just ask you, maybe you are close to this one because it comes from your submission. At page 15 and 16 of your submission, there you've cited the policies of the CMS. So at the bottom of page 15, you say that in an additional CMS document entitled Accreditation Standards for Third-Party Administrators, sections 1454 and 1455, you state the following: membership is suspended, terminated in accordance with the specific rules of a medical scheme on submission of fraudulent claims. You turn over the page, membership is suspended, terminated in accordance with the specific rules of a medical scheme on committing a fraudulent act. And then furthermore, section 1457 states that the member is advised timeously in writing of any action contemplated above. What we've heard here is that a doctor will typically be informed after the suspension that you are now suspended and you will not be entitled to lodge claims. And yet the CMS guidelines require notification of action contemplated, in other words, in advance. So I know you will say that, well, I don't know what the schemes actually do, but assuming theoretically that someone is informed after the suspension, what would be your comment?
My comment, Chair, would be, I think that would be unfair and, unfortunate. What we have come to know is that before these kind of, suspensions are imposed, there would be ongoing or necessary, interaction with the relevant parties. But again, this is based on the interactions that we have with the medical schemes and administrator. But what you are raising is what my comment is as far as that is concerned. And my sense is, if practitioners know after the fact, when they have already been suspended, that would certainly be unfair.
Well, I mean, to say after the fact might also not put the full picture to you. I think some of the testimony we've heard is that what a scheme typically does, it will tell you that you are hereby suspended pending the outcome of an investigation. So at the time you learn that you are subject to an investigation, your entitlement to claim is suspended. Now, according to what you've cited under the CMS guides, you must be notified before. So that's what I'm putting to you, to say that as a practitioner getting a notice saying you're under investigation and you've been suspended pending the outcome of the investigation, that you would say is wrong. Sorry, Ms. Mosia.
Yes, thank you, Chair. Coming to that point, what we've learned is that, and what we're aware of, is that the perpetrator, or if there is a question around that with a healthcare professional, there's always ongoing communication before the action is taken. So the schemes do interact with the service provider prior to them being given that letter of suspension or any other punitive action taken.
How do you know that, Ms. Mosia?
Well, we've learned that through when we interact with our schemes in terms of, and so far we have actually wanted to interact with the schemes to say, what is the process? Do they have processes? And there is proof of processes that they actually enter into to say that we will communicate with the doctor to say, but this, because remember, there could be erroneous reasons for the discrepancy as well.
Would you agree that if it were so that a practitioner was informed at the point when he or she is being investigated, is informed that he or she is also suspended, that would not be appropriate?
Yeah, let me answer that. I would certainly agree that's unfair, and in the context of these practices not being consistent with these guidelines that we're making reference to, Chair, that would certainly be an unfair, we would argue.
And so you set out, so speaking of compliance with what you've set out the CMS policy and procedures, you've also set out the law, various aspects of the Medical Scheme Act and regulations, but you don't say anything about how you understand, how you analyze those sections and those regulations. Can you give us a bit more insight into that? You've set out the law. Do you think Regulation 6 is part of implementation of Section 59.3?
We certainly think it is relevant to be taken into consideration in how Section 59 is implemented. However, our reading of both the Act and the regulation is that it certainly doesn't take away, the right, if you like, on the part of medical schemes to, to deduct monies that medical schemes believe have been paid, fraudulently, even beyond the 30 days, if you like. So the interpretation that we, apply to both Section 59 and Regulation 6 is that it doesn't take away, the need on the part of the medical schemes and administrators to recover funds retrospectively.
Okay, let's accept that. But it certainly, wouldn't you agree that Regulation 6 is, what is required is more than just taking it into consideration, but actually complying with Regulation 6? Because Regulation 6 deals with the process. Don't you agree that it's incumbent upon the schemes to comply with Regulation 6?
No, certainly. And in as far as what Regulation 6 and Section 59 requires of, the schemes and administrator, to do, we would certainly support that, all the parties need to comply. What becomes necessary, however, is, the parties like the Council for Medical Scheme as the regulator to bring clarity in as far as the interpretation and the application, of both the Act and Regulation 6, to the extent that, it is exposed to interpretation.
Perhaps I can just add to that question. So can I assume you accept that a coding error made by a doctor is erroneous? Would that be correct?
No, we cannot always assume it's erroneous, because what one is not able to test is the intention, because it's very possible, it's a possible scenario for a doctor to do that intentionally, so it becomes difficult to say. And these are the things that tend to come out in the interaction, I would imagine, between the doctor, and the scheme.
So in this environment, I would have assumed you've listened to some of the proceedings, but it's pretty clear from what we've heard so far that the coding environment is very ambiguous, to say the least. There aren't, the RPL isn't in force, the ethical tariff isn't applicable. Schemes are creating their own versions of the RPL which are applicable to their members. It seems that it's very easy for the doctors to make a mistake in relation to coding. So the difficulty I have is with that. It seems that often there is no intent on the part of the doctor, yet they may be subject to a clawback many years later in relation to that.
I certainly understand that, in the context of what you have just outlined with relation to coding and the lack of clarity as far as that is concerned, errors are bound to happen. And how this, is approached must be with due consideration to those realities, in mind. But again, given that the use of coding to defraud the scheme is also possible, it's difficult to conclusively say every time there's a wrong code that has been used, it's definitely an error.
Can I just ask, on this topic of investigations, is it your view that a suspension before the completion of an investigation is, let's put it differently, is not in accordance with the CMS guidelines? So if a scheme suspends a doctor before it finalizes its investigation, that would be in breach of the CMS guidelines. Is that your submission?
Chair, it's a difficult one, because it really depends on the nature of interactions that would have taken place before that investigation is finalized. So it's very possible for the conversations to come to a point where the extent or the nature of the interaction doesn't give the medical schemes enough assurance about the claims in question not being fraudulent. And at that point in time, if based on the information that medical schemes may have, suspect that something is amiss about those claims, I would say there would certainly be a right to suspend in the course of engaging the service provider.
I accept that, but you see, we're working on broad principles, best practice, and there will be exceptions where a case is egregious or clear-cut fraud. But as a matter of best practice, bearing in mind that you are the association that represents medical schemes,
yes,
even though you are not a scheme, would you agree that as a matter of best practice, a scheme should not terminate membership before it finalizes an investigation?
I would agree, Chair, and I think in the discussions with the Council for Medical Scheme and other stakeholders in this space in as far as how the code of conduct should spell these things out going forward. What you've just expressed is certainly some of the inputs that we would make in that conversation. But it will certainly require all parties to commit to definitely manage fraud, waste and abuse as far as possible. But my short answer to your question is yes.
And then there's another where you are not completely terminated or blocked, but where they put you on what they call indirect payment.
Yes.
Would you also accept that the indirect payment as a measure by schemes should not be resorted to until the investigation is completed?
Chair, as far as that is concerned, and in this specific instance, I'm assuming that suspension means a member, is being paid. So to the extent that this is something that the Act allows for in as far as either the member or the service provider being paid, if based on the weight of the information available at the time, in the context of an intention to try to manage, or mitigate against possible fraud, the administrator or the scheme is of the view that they are not comfortable to make the payment directly to the service provider. I think, with reference to the Act, it would certainly be fine if they make a payment to the member instead of the service provider.
And would you say that despite the incomplete nature of an investigation, you see that the difficulty with this is that one must take away the focus on the cases that are before us and then think about broad policy in order for us to be helpful to the industry. So what you have a typical doctor who's been on a network or pre-authorization, anything, for years, 5, 6 years. The scheme picks up something, maybe a coding error, maybe innocent, maybe fraudulent, right? The question that really arises is, at what point do they block you? I think we understand that the blocking is a drastic measure. It must wait until the investigation is finalized. But at what point do they then put you on indirect payment and pay your patients directly, you see? From the doctor's point of view, they say it's unfair to do it before the investigation is completed so that I have proven my innocence, you see. So that's what I'm trying to understand, if you would agree as a matter of best practice, that it's preferable that it should only be at the time at which the investigation is completed.
Debra, do you want to answer that? So Chair, as a matter of best practice, and I think as part of the commitment that would be made by all stakeholders to really collaborate, in this and work together, I think what you are suggesting would certainly, be fair in as far as going forward is concerned. I think it will also be important, for this process, hopefully, to come out with recommendations that will not necessarily diminish any recourse available to medical schemes and administrator in their attempts to contain fraud as far as, as much as they possibly can. At the same time, the element of fairness must definitely be introduced and strengthened in that kind of process. So from a policy perspective, the way you've articulated and, going forward, it would be a fair expectation to express.
I think my colleague has a question.
Just one question very quickly, just a clarification at page 15 of your submission where you cite the CMS policies and procedures. At 1.4.5.5, the policy states that membership is suspended or terminated in accordance with the specific rules of the medical scheme and so on. Is membership there meaning membership of whose membership? The beneficiaries of the scheme, or or is that the service providers, the doctors?
Chair, it can only mean the member, the beneficiary, because a service provider would not be a member in this context.
Right. Okay. So it would be the beneficiaries who have to be notified.
Correct.
In advance.
Correct.
Yes, but I mean, I hope you understand my question relates to service providers and not to members. The policy question we were debating.
Yes, I understood that. Yeah.
Thank you. Ms. Mosia.
Thank you. And what I'd like to say is precisely what Teddy has already said, Mr. Msumutane has already articulated, is that this process precisely, we're finding ourselves in this situation because, yes, we need to get to a point where there can be some kind of fairness in the system that we can start using for service providers when they get blocked. But the point that I wanted to just say now is that we also both parties are responsible. So in the process, I'm urging that when you do come up with the recommendations, do look at the other end of the process on the supply side, because we do need a lot of cooperation as well from the supply side of this transaction to say that if, for example, information is required, it does get, provided at the time that it should be. And therefore, then, I guess it will reduce the delay that does eventually come out of the process. So that's just the plea that I wanted to put forward.
Can I put something else to your association as well? So one of the complaints beyond the stage at which a doctor is taken out of direct payment is the way that the investigation is conducted. Doctors are required by non-medical people to submit confidential information. And somebody made the example, I don't want to diminish the status of the forensic investigators, but someone made the example of ex-policemen descending upon your practice and demanding access to clinical notes. What is your view on that? Because I don't see it addressed in your submission.
Chair, our view on this, we would prefer to really defer this to the administrators and the medical schemes who will be here to really provide context, around circumstances where these kind of measures apply. I'm also aware that, where questions have come up in this regard, the responses have included, legal opinions that, administrators in particular have made reference to in as far as, what is possible or what is allowed or what is within the boundaries of law and what is not. I think it will be a more complete kind of response when, the medical schemes and administrators provide a full response in relation to those kind of practices.
No, I accept that. We will ask them for the specific detail, but I still want to get just a broad principle understanding. The complaint is under the Act and in terms of our code that we are subscribing to under the Health Council, we are not required to submit confidential patient information, right? So as a matter of policy, what would you say to that? And especially not to people who are not medical practitioners themselves.
I would say the expectation is that we must comply with the law, in our practices there. It's also important perhaps to mention that invariably the clinical information that would emerge out of a consultation transaction, the medical scheme would have it, anyway. So it's partly this context that I think medical schemes and administrator will be able to provide. And the point that I want to get across, Chair, is that the clinical information the medical schemes would already have, and the questions that we'll probably have to deal with at a later stage is what exactly is the nature of the information that may be required as part of the investigation, because the medical schemes would invariably have the confidential and clinical information already.
And a further question on a similar point. We've heard allegations from doctors that medical schemes and administrators interrogate the amount of time spent with a patient, and practices will be flagged on that basis. The concern here is that the amount of time spent with the patient seems to be inherently a clinical decision of the doctor, and there's a concern about the interference by medical schemes and their administrators on this part. Can you give your comment on that?
Chair, I think context becomes important here, is because if any specific consultation with reference to that specific case suggests that this is definitely an outlier, if you like. Our understanding that it's based on that questions would be triggered, just to get absolute assurance that there's definitely no fraud, waste, or abuse in as far as that transaction is concerned. So I suppose the way that interaction takes place is something that needs to be visited, revisited, and influenced by whatever code of conduct will emerge from the conversations currently underway. So my response is that context is important, but my understanding is that those questions would arise on the part of medical schemes and administrator to make themselves comfortable that what they are paying for or what they've already paid for is certainly genuine and and passes the reasonability test.
Sorry, you want to add something? Yeah.
Just to add to that, Chair, thank you. I think when we engage with the HFA member organizations, what they seem to be saying is schemes are simply seeking to understand. So there's a claim for a service, and was that service actually rendered? And we must remember, Chair, I think on the point of context, how these investigations are triggered are not just through analytics, it's also through tip-offs. So if a member, a patient says, I've just been billed for this and I never went to see this doctor, or I was there for 30 minutes and I see I've been billed for 2 hours, right? The scheme in that case is looking for some kind of verification. They already have information on the claim to say this was the diagnosis, this was the treatment, but I think what they're trying to do is saying, okay, given this suspicion, how do you then, can you please verify that the service was actually rendered in the same manner as it was claimed for? So I think it's hard to kind of respond to these at a broad principle level, but I think it's quite clear here that both parties have a responsibility to kind of operate with trust and in a truthful manner. And our understanding is that most claims are actually paid, the vast majority of claims are actually paid in good faith, within the 30-day required period, because it's not only about service to the member and the doctor, it's also about if you delay payment, you potentially delaying access to benefits in a way, because that benefit would not until day 30 have been paid for. So I think it's hard to respond to the specifics until we kind of have the schemes and administrators' response. But I hope my answer kind of at a principle level just provides the position from HFA's point of view. Yeah.
Just to clarify that then, would you say in principle it's not fair to have a practitioner questioned by someone who isn't at least equivalently qualified?
Not necessarily. I don't think I would necessarily agree with that. I think if you're simply saying, can we have verification that you actually saw the patient, you're not asking a clinical
in the context of the question I'd previously asked, so sorry for my lack of clarity, but in relation to, for example, time spent with a patient, over-servicing, etc., those decisions that are inherently clinical.
Okay, thanks for that clarification. I would say it depends on, I think in a world where everything is fair, the practitioner is engaging openly and willing to, to assist in the process, it's probably not going to be a very confrontational conversation. I think the worst case scenario is practitioners who have perhaps willfully submitted, claimed inappropriately. Try and use patient confidentiality as an instrument to kind of not disclose or provide verification information. So I think, it's, I'm sorry if I'm not giving you a generic answer, because I think there are times where it's simply inappropriate, we think, from a healthcare provider to say, well, the only source of this information is very confidential information, and I cannot provide for that. What schemes are also saying is that the patient, the members, in their application forms, and I'm not sure whether this is true for all schemes, we'll have to establish that, have already upfront given permission for information relating to their care, have given the scheme consent for these kind of purposes to source this information. So it's not ideal. I mean, I think the short answer is it's not ideal for to ask for information that is not relevant to the problem you're trying to solve. And that's not, we certainly, I would agree with you there in principle. But at the bare minimum, the information provided should be sufficient to verify the claim. If I may give an example, if a healthcare professional could have a system where they simply say, upfront, I'll have a patient name, time in, time out, and patient signs on their way out. That would be good enough to, if the healthcare practitioner provided that kind of information to say, here, I have a schedule in my practice. Patient X came in here at 10 o'clock, left at 10:30, and I billed for 30 minutes, and the patient signed for it. Then, you don't, if you had that as a tool, then you don't need to actually go into discussions around, show me from clinical case notes. So the information required is not really that, it's not clinical information. It's really just to verify that the service has actually been given.
Yeah, I mean, I presume you agree in principle. I don't know if you do, I don't know how to put words, that if it's clinical related, there should be an equivalently qualified person assessing it.
I'm not sure on the practicalities of that. So if it's a cardiologist, are we saying I'm not being cheeky here, I'm just trying to get clarity. Would that question mean on a like-for-like basis, the scheme now is required to source a cardiologist to interview that? I think it's just the practicalities of doing things that way would be difficult. I think a possible remedy to these sort of issues could be that you have, a clinically qualified person, either employed in the administrator or independent, who is present to kind of assist with these sort of processes. That might be, a kind of reasonable remedy just for some of these tricky situations.
Well, I mean, I don't think the question from Ms. Williams was that a cardiologist must go and conduct the work of forensics. But the point was that it should be reasonable when you submit information that the person receiving it must at least be capable of interpreting it.
Absolutely.
The question comes from the place where we squarely had an allegation that obstetrician was questioned by GP, if I recall correctly. And there is something, for me, certainly inherently odd about that, because the speciality is the speciality, and the professions are different, put it that way.
I'm not sure. GPs are trained in obstetrics and gynecology. So they have, GPs in this country are fairly well versed on all the disciplines, and they have a fair enough understanding on issues. And I think if you had a GP asking these questions, I wouldn't think that's unreasonable. I think what seems unreasonable is to expect each and every medical scheme to now have a panel of ENTs and cardiologists to deal with case-specific requests. Just the practicalities of that.
No, it could be managed by a central body. It's not necessarily a burden on the scheme. But it's just a matter of principle. Forget the pragmatics.
Yeah.
but as a matter of principle, it strikes me as odd to have a non-qualified person asking any professional interrogating clinical-related decisions, and even, let's say, a GP questioning a specialist.
Yeah, so I think in terms of just basic verification of a service, I don't think you need a clinically qualified person to say, did a visit actually happen, did a consult? So I think that we've dealt with. To the extent that a clinical conversation is necessary, I wouldn't think that's an unfair dispensation to look at.
Thank you. How far are we now with our PowerPoint? All right, let's finish the 2 slides.
Now, as far as forensic services are concerned, the only point that we want to highlight here, I am going to take advantage of the panel having seen some examples of, the fraud that our schemes and administrators find themselves having to deal with, which include charging for services not rendered, modifying billing codes, what we have referred to as ATM and card farming. And the point that we want to get across here is that it's important for trustees in particular, it is their fiduciary duty to make sure that to the extent that they can have risk management practices that manage our exposure to these activities, they must certainly do them. Fraudulent practices that are identified are also reported to the relevant authorities, including SAPS and HPCSA. But it becomes important for trustees in particular to have a handle on what is happening in this regard. In conclusion, Chair, now the medical scheme industry embraces the social solidarity principles enshrined in the Medical Scheme Act, as I indicated very much earlier on. The medical schemes are experiencing significant cost escalations driven by a multiplicity of factors, including demand side and supply side factors. So scheme trustees, Chair, have a duty to maintain a sustainable balance between accessibility of benefits and affordability of members. This includes ensuring members' funds are adequately protected against fraud, waste, and abuse. Based on the numbers that we have touched on, we think fraud, waste, and abuse does present itself as a significant contributor to medical inflation. Now, if I can quickly share with you some of the key themes that came out of the Fraud, Waste, and Abuse Summit that was hosted by the Council for Medical Schemes, which will be fed into ongoing conversations going forward on this matter, include a common framework for forensic processes, emphasis on fairness and transparency. And this takes into account some of the things that the panel has highlighted here, and we certainly embrace these suggestions. Industry standards for coding and billing will be important. Peer review and or support to be incorporated into interventions. Now, Chair, CMS Section 59 investigation, HFA is of the view that the schemes and administrators, based on what we have come to know, are interpreting Section 59 of the Medical Schemes Act accurately, but I have to qualify that by saying we are certainly trusting this process. What will come out of this as recommendations will be given due consideration. We have not been made aware of any conclusive evidence of racial profiling, in particular. And I also observed in the course of the week a conversation that was suggesting that, look, maybe it may not be by design, but the implication of our practices may affect a certain, population group. Now, we as HFA are not aware of unlawful application of forensic procedures within its membership base. And an HFA code of conduct on fraud, waste, and abuse is being developed. It will support and align with the CMS code of practice, which is currently in draft format. And Chair, that's it.
Thank you. Could I just ask you something about what is in page 17 of your submission? Because this is an issue that was raised by the Competition Commission. See, under conclusion way forward, the second sentence, you say that it is important to recognize that the funds recovered from identifying and preventing fraudulent practices directly benefit medical scheme members through their availability for paying benefits as well as reducing contribution increases. Now, there are two complaints here. The one is that there is no transparency with what happens to the funds that have been recovered under the umbrella of preventing fraud, waste, and abuse. The second is that in reality, they don't benefit members because contributions are not going down and contributions have been going up for the past 10 years. So what do we know about what happens to the monies that are recovered under the umbrella of FWA?
Chair, our understanding is that they certainly go back to the schemes. And the reality is, if those funds were not recovered, the contribution increases would possibly be a lot higher than they have been. So essentially, given that they are high as they are, and sustainability is a bit of a challenge, it makes it even more important for us to pay attention to a variety of cost drivers, including fraud, waste, and abuse. So in short, the funds certainly go back to the scheme, and if they didn't go back to the scheme, based on the actuarial work that is done leading up to annual contribution increases, they could potentially contribution increases that is be a lot higher than is the case had we not recovered those funds from fraud, waste, and abuse.
Well, yesterday we had evidence that the forensic investigators are charging extortionate amounts to the tune of 36-37% of what they recover.
Chair, we have no knowledge, of that, and what we would be aware of is any support that is provided by administrators to their medical schemes in as far as fraud risk management. And we have no knowledge or information about what any other parties may charge in this regard.
How much do the administrators get out of this?
It will vary from scheme to scheme. We have no indication of any additional layer of cost that is attributable specifically to fraud, waste, and in abuse. And I know there would be administrators who really see this as part of their bundle of services in support to the medical schemes that they administer. But a short answer to your question, we have no figure that we are aware of that is specifically charged by administrators, for fraud, waste, and abuse.
Thank you. Unless there are any other, yes, Ms. Musia.
Just to add on to the topic that we've just been on, is to remind the panel also that some of those, the recoveries would also be based on erroneous transactions that were made. Either, that would be non-intentional erroneous claims. So that would be justified, that it would come back to the to the scheme. So this is now in response to the notion that, not the money actually belongs back to the member. It must be reimbursed to the member, which is what we've heard over the past few days. So just to make a point there that there are those erroneous transactions where the monies have to come back to the scheme for.
Thank you very much. Well, unless there are further submissions on your side, it just remains of me then to thank Mr. Musomotane and his team for being present, making submissions, and having submitted written submissions to us at the time this process was closed. We will obviously be coming back to you with requests for further information, further data, and the conversation will continue. The schemes are only scheduled to appear in September, so perhaps before the schemes appear, we may be sending further letters and correspondence and requests for information. So thank you for your cooperation and your participation.
Thank you.
We are going to take a short adjournment. We're going to take a short adjournment. It's 10 to 12, so we should probably come back at 12:15. We were scheduled to take the Department of Health at 11:30, but we are running a little bit behind schedule. So I hope they are already here. Somebody knows them. So let's adjourn for 20 minutes. We will come back at 12:15. Thank you.